Welcome. This is Perry Carter, and we continue our Supreme Court series with the case Brown versus Board of Education. Little context on this case. The year is 1952. The Civil War ended almost 100 years before. African Americans, while being free, do not have full access to all that America offers its white citizens. The law of the land separates blacks and whites, particularly in the southern states, and segregates the races in every aspect of life, from restaurants to schools. The law of the land says it is constitutionally legal to separate these elements as long as they were equal in quality. In reality, black facilities were separate, but in most cases not equal. This case tested that notion as it related to schools. Brown versus Board of Education of Topeka, Kansas. This was brought about by Oliver Brown on behalf of his daughter. The case was argued on December 9th through the 11th of 1952, re-argued December 7th through the 9th of 1953, and finally decided on May 17th of 1954. And you can see there were a number of co-advocates in this case. So what are the facts? This case was the consolidation of cases arising in Kansas, South Carolina, Virginia, Delaware, and Washington, D.C., relating to the segregation of public schools on the basis of race. In each of the cases, African American students had been denied admittance to certain public schools based on laws allowing public education to be segregated by race. They argued that such segregation violated the Equal Protection Clause of the 14th Amendment. The plaintiffs were denied relief in the lower courts based on Plessy v. Ferguson, which held that racially segregated public facilities were legal so long as the facilities for blacks and whites were equal. This was known as the separate but equal doctrine. And I basically say the black families which brought this to their local courts were not granted any relief on this law based on the fact that they said the schools were separate, but they were equal. So it was brought to the Supreme Court. The question: does the segregation of public education based solely on race violate the Equal Protection Clause of the 14th Amendment? The conclusion: by a unanimous decision for Brown and Company, it gave a majority opinion to the Browns. Separate but equal educational facilities for racial minorities is inherently unequal, violating the Equal Protection Clause of the 14th Amendment, which was ruled by the court. Chief Justice Earl Warren delivered the opinion of the unanimous court. The Supreme Court held that separate but equal facilities are inherently unequal and violate the protections of the Equal Protection Clause of the 14th Amendment. The court reasoned that the segregation of public schools based on race instilled a sense of inferiority that had a hugely detrimental effect on the education and personal growth of African American children. Warren based much of his opinion on information from social science studies rather than court precedent. The decision also used language that was relatively accessible to non-lawyers because Warren felt it was necessary for all Americans to understand its logic. It said, in short, segregation in schools did not offer equal protection under the law, and it made black students feel inferior. So there you have it. We have a lot of information for notes. Take those notes and hit it and quit it. Let's get it done.